Hello, everybody, and welcome back to the channel. As we have some legal updates to give, we're back in the studio sitting in front of a camera. Here we go. There are some interesting things coming out of Florida, my home state, and I did a little bit of research on this and came up with, quite frankly, another case out of another state that directly relates to writing of sexual predator or sexual offender onto the driver's licenses. This affects, an awful lot of people, probably upwards of 1 million people. But before I get started, let me say that if you enjoy what we do and you want to encourage us, or if you want to participate, you are welcome to join us on Sunday afternoons. That would be Sunday afternoon in the United States. Obviously, here in Germany, it's Sunday night. And we meet every Sunday on Patreon, and you are welcome to join us. Please feel free to do so, where you can ask us questions directly. You can share opinions, do a song and dance if you like, whatever. But join us on Sundays. So having said that, let me jump right into it. Florida, the 5th District Court of Appeals recently issued a 2-to-1 decision determining that to write sexual offender or sexual predator, not to write but to print, on your driver's license is compelled speech which violates a person's First Amendment rights. Therefore, this court has said that Florida must remove those words from driver's licenses. Not so fast. It was only a 2-to-1 decision in an appellate court, and that decision has been stayed because it's now going to be raised to the Florida Supreme Court. The Florida Supreme Court is very conservative. Not sure exactly what they'll do with this issue, but when it comes to sex offenders, they almost always strike against. So while I'm very pleased with the 5th District, I'm not sure what the Florida Supreme Court is going to do with it. Interestingly, this case actually started back in 2020 in Louisiana when the Louisiana Supreme Court issued a decision saying that printing of sexual offender or sexual predator on driver's licenses is compelled speech in violation of the First Amendment. The government of Louisiana then challenged that decision in the United States Supreme Court. However, the very conservative United States Supreme Court declined to hear the issue. So the Louisiana decision stands. So if you are, or anyone you love is living in Louisiana and they are on the registry, they do not have to have that printed on their driver's licenses. So someone in Florida is trying to do the exact same thing. District Court 2-to-1 decision went with them. If the state of Florida follows the precedent of Louisiana, then they're going to rule the same way. They're going to uphold that decision out of the 5th DCA. Having said that, Florida is not bound to follow the decisions of Louisiana because Florida, just like any other sovereign state, gets to make decisions for itself. So if they rule different than Louisiana, it's possible that we might actually have the case end up in the United States Supreme Court. So we would have the Louisiana decision versus the Florida decision with the Supreme Court trying to figure that mess out. But this got me thinking about something. If writing sex offender or sexual predator on someone's driver's license is compelled speech, in other words, it forces someone to admit or identify themselves as being on the registry, doesn't that make a public registry itself a violation of compelled speech? Now, it's not an original thought to me. This is a legal argument being raised by groups like NARSOL and Axol and others. But it seems to be pretty clear. Because if my name and my face and my address or what have you is online in Florida under a sex offender registry, I am being forced to tell everyone that I have been convicted of a sex offense. Seems to me compelled speech in violation of the First Amendment. I don't have, and I've said this before, I don't have a problem at all with people who violate the law being held accountable for their actions. I don't have a problem with that. And I don't have a problem if the government wants to keep a record of people who've been convicted of certain offenses. We do this with people who are not convicted of sexually related offenses. We do this for every crime. There is a log of every person who's ever been convicted or even arrested for misdemeanors or simple battery or robbery or grand theft, what have you. There are registries. My objection is to it being public because it's not only a public humiliation and shaming, but it is a violation of compelled First Amendment speech. It's a very slippery slope when we say it's okay to do it to this group. We're not going to do it to any other, because they don't do it to murderers and they don't do it to robbers. There is no public registry of them. We only do it to sex offenders. But that's okay, because Nazi Germany said, hey, we're only doing it to the Jews. Okay, we know where that went. I'm against it. I'm against it. So I very much appreciate the 5th District Court of Appeals in the state of Florida for standing up for First Amendment speech, even for a group of people that are difficult to defend. And I applaud Louisiana for doing it also. So, glimmer of hope. So I hope this brings you some encouragement. I hope it gave you some food for thought. And, let me give some credit out there to Axol, Narsol, and these groups that are out there fighting this, who are trying to make a difference. So keep up the very good work. Until next time, my friends, be safe, be smart. And if you're not happy with your situation, whether it be Florida or Louisiana or any other state, do something about it. Till next time, my friends. Tschüss.